Is Congress actively shielding extremists? House Judiciary Chairman Jim Jordan just demanded a civil rights watchdog drop its hate group label from the Alliance Defending Freedom, an organization relentlessly fighting in court to strip legal protections from LGBTQ individuals. To justify this, Jordan's star witness was Tony Perkins, president of another designated hate group, the Family Research Council. Perkins argued the watchdog must be shut down precisely because its civil rights educational materials reach 500,000 teachers and military officials. This chilling testimony is now official congressional record. The stakes are terrifyingly clear. If politicians successfully silence this watchdog, the public will completely lose track of which extremist groups are secretly funding and influencing your local representatives. Watch this unfold.
Mr. O'Neill, they had an extremist file webpage, didn't they?
Yes.
And they would, on this webpage, they would pick out some crazy hate guy, and they would, some bad guy, and he was like the extremist of the month. They'd highlight him, and they would say, send us money to stop so-and-so. Is that right?
Exactly.
And F42 was one of the field sources, number 42, chair of some crazy hate group. The Southern Poverty Law Center highlighted him on their webpage. He's bad, he's evil, send us money. Is that right?
Yes.
Did they tell their prospective donors they were paying this guy?
No.
They didn't tell him. Did they tell him they were paying him $140,000?
No, not to my knowledge.
So they said, let's stop the racists even though we're paying him to be racist. That was their pitch. But they didn't tell him that, did they?
No, they did not.
Is that appropriate, Ms. Wiley?
I'm sorry, which part? Sorry.
All of that. Is that appropriate to say, tell your donors, this is the extremist of the month, this hateful racist guy is really bad, send us money, but not tell those donors who you're taking their money from that we're paying this guy $140,000. Is that appropriate?
Well, we have public reporting that over a dozen donors actually said that they spent the money as intended.
Field Source 42 got $140,000 from the Southern Poverty Law Center, was featured on their webpage as extremist of the year or month or whatever they call these bad guys, and they were paying him and they were gating money. Is that appropriate? Simple question.
And donors have supported it, and they keep trying to send more money to the Southern Poverty Law Center.
Is that technique appropriate? That's what I'm asking.
That is not unlawful to say that people have done
I didn't
X,
ask if
Y,
it was lawful or
Z.
unlawful. As you said earlier in your testimony, the court's going to determine that when they go to trial. What I'm asking you, is it appropriate?
As I said, the donors have spoken. And in fact, they're trying to send more money now, and their financial institutions refusing to send the money.
Is the Alliance Defending Freedom, is that a hate group?
I don't know. I don't do designations.
Well, they've argued 16 cases before the Supreme Court, won 16 cases before the Supreme Court. They stand for traditional values. Southern Poverty Law Center labeled them a hate group. Are they a hate group?
I don't know them, and I don't work on the designations.
Well, here's one thing.
I'm here to talk about
let me ask you this. Is Jane's Revenge, is that a hate group? Because the ADF, they didn't firebomb anybody, but Jane's Revenge did. ADF is labeled a hate group. Jane's Revenge isn't. I want to know how you would label it.
I'm not here as a person who designates groups. I'm here to talk about the impact on civil rights.
Okay. Mr. O'Neill, you think any of these field sources were double dipping? I mean, during the Biden, Ray, Garland administration, the Justice Department paid a bunch of confidential human sources, a bunch of them. We know a bunch of them were at the Capitol on January 6th. 4 went in the Capitol. And I'm just wondering if the same entity, the Justice Department under President Biden, paying these confidential human sources, who was working with the Southern Poverty Law Center, having quarterly meetings with them, consulting with them, giving them FBI data before anyone else could see it, having them train their prosecutors. I'm just wondering, do you think it was out of the realm of possibility that the Justice Department was paying the same sources the SPLC was paying?
I don't think it's out of the realm of possibility. I have no information or knowledge that they were double dipping. I would say that Stephen J. Ross, who is author of The Secret War Against Hate, which is about the history of informants that Jewish groups had placed in some of these violent groups back, decades and decades before the SPLC ever existed. He said that neither the ADL nor the American Jewish Committee nor the Anti-Nazi League did anything like highlighting informants online as in extremist profiles while also funding them.
Yeah. Last question will come to you, Mr. Perkins. In your opening statement, you talked about how it was just worse than the SPLC because how they've put themselves out there or become the standard, help from the government, I think, in becoming the source or the standard on evaluating and determining what groups are hate groups, what groups aren't. But it's bigger and broader. It has things. But I think the real thing here is how closely they worked with the government to carry out what they were trying to do. And the reason the Biden administration embraced them, I think, so fully was politics, simple politics. You agree?
Well, there are members of this committee that were endorsed by SPLC. They had a C4 was involved in elections, so they were not just an umpire; they were a player on the field as well. So how can they be objective in determining who is a purveyor of hate and who is not? I mean, they had a stake in this. But to your point about their engagement with government, it goes much further than the federal government and the FBI and the Department of Justice and the Department of Defense, which their material was in briefing to the members of the military. But they also continue to have their Learning for Justice, which is about 500,000 educators across America, and bulletins to local law enforcement. And I happen to know because the agency I was with, the sheriff called me and said, "Hey, we got a bulletin that says you're a part of a hate group."
Yep.
And he was laughing.
Yep.
But that is the reach that they've had. This is the hub. They're the hub, but they're spokes that go out and...
No, I think that's an appropriate metaphor. My time has expired. With that, I recognize the gentleman from Georgia.
On April 21st of this year, a federal grand jury in Montgomery, Alabama, returned a criminal indictment charging the Southern Poverty Law Center with wire fraud, using electronic communications to steal money, false statements to a government-backed bank, and plotting to commit money laundering, secretly moving funds to hide where they came from. The charges aren't vague. Federal prosecutors allege the SPLC secretly sent more than $3 million in donor funds between 2014 and 2023 to individuals affiliated with the Ku Klux Klan, the Aryan Nations, the National Alliance, and the American Nazi Party. These were the same groups. Its fundraising emails were demanding money to dismantle. The organization has denied every allegation and says it will fight this in court. But here's the thing. The payments prosecutors allege didn't run through anything traceable. According to the indictment, confirmed by both NPR and CBS News, the SPLC opened bank accounts in the names of fake organizations, including Center Investigative Agency, Fox Photography, and Rare Books Warehouse, to move money toward individuals secretly placed inside extremist groups. The DOJ says those accounts were designed specifically to disguise the true source and control of the donated money. The SPLC counters that the program was kept confidential to protect the physical safety of its sources. That's their defense. Hold on to it. Here is where the allegations get impossible to dismiss as ordinary nonprofit fraud. The DOJ alleges one SPLC paid informant, identified only as F37 inches court documents, was a member of the online leadership chat group that planned the 2017 Unite the Right rally in Charlottesville, Virginia, the rally that killed Heather Heyer. According to the indictment, F37 attended the rally at the SPLC's direction, made racist social media posts under the organization's supervision, helped coordinate transportation for attendees, and received more than $270,000 for that work between 2015 and 2023. The SPLC disputes every part of that claim. So let's talk about what happened to the SPLC's fundraising in the months after Charlottesville, because this is documented financial fact, not theory. According to its own tax filings, the organization collected roughly $51 million in 2016. In the year ending October 2017, the year of the rally, that figure surged to $132 million. The Clooney Foundation for Justice donated $1 million to the SPLC, explicitly in response to Charlottesville, confirmed through a joint statement from the foundation. Apple CEO Tim Cook pledged $1 million to the SPLC specifically as part of Apple's $2 million total split with the Anti-Defamation League. JP Morgan Chase directed $500,000 to the SPLC, its share of a $1 million pledge split equally with the ADL. Real people reacting to a real event in which a woman died and dozens were injured wrote those checks. Whether an SPLC paid informant helped produce the event that generated that surge is a legal question, not a line item in a tax filing. And look, The full size of the alleged network matters here. According to the indictment, one individual affiliated with the neo-Nazi National Alliance allegedly received more than $1 million from the SPLC over a 9-year period. The indictment also identifies a source the DOJ alleges was the Imperial Wizard of the United Clans of America, and a third allegedly linked to the Aryan Nations-affiliated Sadistic Souls Motorcycle Club. All of these are allegations, not convictions allegation. In 2018, the SPLC paid $3,375,000 to Majid Noaz, a British Muslim reformer it had wrongly labeled an anti-Muslim extremist in a journalist's guide. Noaz has described it as the first and only successful legal challenge to an SPLC label. And here's what's so telling about that payout. It showed that these labels carry real legal consequences when they're wrong. What it did not do was force the organization to change course in any meaningful way. The FBI relationship continued. The Pentagon briefings continued. The curriculum kept shipping. Why? Because the problem wasn't a mistake, it was a method. The SPLC's own published definition of hate groups restricts the label to organizations that target people based on characteristics they can't change. Race, religion, sexual orientation. That definition, written by the organization itself, is designed in a way that automatically leaves out groups that target people for their political beliefs rather than for who they are. What it produced was a framework that locked certain political organizations into government training materials and corporate donor blacklists, while groups that literally firebombed pregnancy centers over reproductive policy fell outside the rules entirely. He received $3.5 million and a public apology. The unreversal question: once a Pentagon training document, an FBI threat report, or a corporate anti-hate policy has put your label on its official list, what is the mechanism that removes it? Nobody has answered that. There is a court-established case, not an allegation, a conviction that showed exactly what's at stake when someone takes an SPLC label and acts on it. On the 15th of August 2012, Floyd Lee Corkins II attacked the Family Research Council in Washington, D.C., armed with a 9mm pistol, multiple ammunition magazines, and Chick-fil-A sandwiches he planned to smear on the faces of his victims after killing them. A security guard, shot in the arm, prevented the massacre. In FBI interrogation, Corkins told investigators, "Southern poverty law lists anti-gay groups. I found them online, did a little research, went to the website, stuff like that." He pleaded guilty to terrorism charges in 2013 and received a 2-5-year sentence. That's what a label does in the real world. Now, Tyler O'Neill's book isn't called Making Errors. It's called Making Hate Pay. That title is an argument. The SPLC built a financial model that rewarded finding, labeling, and publicizing hate groups because doing so generated donations. The indictment gives that documented argument federal legal weight. Look at the timeline. The DOJ alleges the payments to informants ran from 2014 to 2023, the same decade the SPLC built one of the largest nonprofit investment funds in the American South. Whether the threat was ever really being dismantled or whether it was being maintained now has a federal indictment as a citation, but that question had a prehistory that's worth knowing. In March 2019, about 24 SPLC employees signed an internal letter alleging that mistreatment, sexual harassment, gender discrimination, and racism threatened, in their own words, the moral authority of this organization. Co-founder Morris Dees was fired that same month. President Richard Cohen resigned weeks later. None of it damaged the organization's credibility or reputation with the FBI, the Pentagon, or corporate America by a single measurable inch. A 14-page indictment accomplished in 30 days what years of documented internal accusations never did. That is not an argument about guilt or innocence. It's a question about how credibility actually works and who exactly gets to decide when it breaks. Now, to be fair, the SPLC's defense deserves a real hearing because it's not trivial. Interim President Brian Farr has maintained that the informant program served a genuine anti-terrorism purpose, gathering intelligence on violent groups and passing it along to law enforcement. The organization says its informants helped prevent a planned attack on a Las Vegas synagogue and gay bar in 2019. It's demanded the full grand jury transcript and called on Acting Attorney General Todd Blanche to take back what it described as significantly false statements he made at his press conference. The trial will give the organization's attorneys the opportunity to make that case, but right now the case proceeds. Here's where this gets deeply ironic. In October 2023, less than 3 years before this indictment, the SPLC's own Hate Watch published a report titled Extremists Get Boost from Donor-Advised Funds. It named Fidelity Charitable, Vanguard Charitable, and the Schwab Charitable Fund as platforms sending money to groups the SPLC had labeled as extremist. Donor-advised funds being specialized charitable accounts that let wealthy donors direct their giving over time. It used that research to pressure those same institutions to screen their grantees more aggressively, and now those same institutions have cut off the SPLC. A Vanguard spokesperson confirmed the policy directly. If we become aware an organization has been charged with a crime by state or federal authorities, we pause grant-making while the matter is pending. That's the mechanism the SPLC helped build. Having their funding cut off because of the extremism charges against them now pointed directly at the organization that built it. Democrats on the committee argued that's precisely the design: inflict maximum damage before a courtroom weighs a single piece of evidence. But whoever designed this standard made something normal that doesn't disappear when the SPLC's trial ends. A rule that cuts off funding before any verdict is reached is a loaded weapon that can be picked up by anyone. And look, I want to be honest with you about the independence of this prosecution because it matters. House Democrats launched a formal investigation into the DOJ's handling of this case after an insider came forward claiming that senior Justice Department officials pressured prosecutors in Alabama to move quickly, disregarding internal concerns about the strength of the case. A Republican-controlled Justice Department bringing criminal charges against an organization that has drawn documented hostility from Republican politicians for decades, while Republicans simultaneously hold a congressional hearing on that same organization that's not a conspiracy theory. That's a factual description of the situation. It doesn't prove innocence, it doesn't prove guilt, but it does mean every element of this case requires examination, not just the SPLC's conduct. What the indictment's core allegation actually means for every institution that relied on the SPLC's labeling system is a question the trial itself won't resolve. If the intelligence-feeding Pentagon briefings, FBI threat assessments, and law enforcement bulletins came partly from paid sources inside, the very groups being labeled people simultaneously on the SPLC's payroll while being publicly denounced on its fundraising platform, then every decision made on the basis of that intelligence has a source reliability problem. The indictment also raises an open question the criminal case itself doesn't answer: whether the DOJ under the prior administration was simultaneously paying some of the same confidential human sources the SPLC was paying. If that overlap is ever confirmed, the contamination extends from the SPLC's own network directly into federal law enforcement operations. Every FBI threat assessment that relied on SPLC-sourced intelligence, every surveillance operation opened on the basis of a tip from someone whose true ties to both organizations were never revealed, the question is no longer about how many institutions the SPLC reached. It's about what those institutions were actually being fed, and whether there is any mechanism in American law or policy to audit, correct, or retract a government decision once its underlying source has been alleged to be based on fraud. Consider the scale of what the DOJ is alleging against the backdrop of a decade of politics. Joe Biden declared at the 2024 Democratic National Convention that Charlottesville was why he ran for president. The rally reshaped how millions of Americans understood the domestic extremism threat. It restructured media coverage, government priorities, and civil rights fundraising for years. The DOJ alleges an SPLC-paid source helped bring the extremists who showed up that day. The factual record, the violence, a woman's death, the political fallout isn't disputed. What a jury will have to weigh is what role the SPLC's own network played in producing it. So here's where we land. The Southern Poverty Law Center built its authority on a single claim: that it could be trusted to tell you who the real haters were. Journalists cited it. Donors funded it enough to build up nearly $794 million in total holdings, according to its own independently verified financial records for the year, ending the 31st of October 2024. What a federal grand jury has now alleged, and what a jury will ultimately determine, is whether donor funds were used in a way that directly went against the SPLC's own public fundraising message. The SPLC remains innocent until proven guilty. That standard applies here as it applies everywhere, and I mean that. But the institution that held the power to influence law enforcement, conversations, public policy debates, government-connected training programs, and hundreds of thousands of classrooms now faces criminal charges for building that power on fraud. Whatever verdict comes out of Alabama, the framework that gave the SPLC its authority is already on trial, and the country is watching. Thanks for watching, and thank you for being part of the conversation. Leave a comment below and let me know what side of the debate you are on. Hit the like button if this video gave you value or made you think. Click the bell icon so you stay updated every time I upload. Subscribe for more political videos, breakdowns, and discussions. Thanks again for watching, and I will see you guys in the next one.